In some foreign jurisdictions, attorneys representing their clients in civil suits have an option to absorb the initial costs required for their case to be heard in court and be paid subsequently from the settlement once they win the case. These costs include attorneys' fees and hiring experts, which could serve to bring further clarity or other perspectives to the matter, and can be done whether the law firm is representing an individual or a group, including in class action lawsuits. This is called a contingency arrangement. According to attorney-at-law Martin George, it assists in cases where the cost of litigation is high or even prohibitive. He says the recent money issues raised by Freedom Law Chambers in relation to the parents who they are representing in their case against the Northwest Regional Health Authority over the deaths of their babies bring to the forefront the matter of these arrangements in the local setting.
Our Legal Profession Act does not have any specific provision set out to guide or, manage that arrangement. And it is time that we in Trinidad and Tobago change our legislation, make the necessary amendments, and legislate to include contingency fee arrangements as part and parcel of our legal landscape.
George says because of the legislation surrounding civil proceedings, a lot of work has to be done at the beginning or during the early stages of a litigation matter before it gets to the court. He tells us this includes appearances at the case management conferences, judicial settlement conferences, pre-trial reviews, etc. According to George, it can create an unequal playing field to getting justice, even more so when the litigation period is lengthy.
For many ordinary litigants, the cost of litigation becomes prohibitive. And then this is more so against a defendant who may be a heavyweight defendant. So if you are trying to sue the state of Trinidad and Tobago, or trying to sue some government agency or some statutory body which has deep pockets, financial resources can run out and you basically may have to abandon your litigation if it is that you are not able to go the distance.
George tells us formalizing an arrangement for contingency fees would augur well for the country and people of limited means.
And it would make the access to justice a lot wider for persons. If there's a contingency arrangement that allows you now to level the playing field somewhat by engaging attorneys of high caliber who can now have a fixed arrangement for payment after the matter is completed and provided that you are successful in the matter.
The attorney says it is not a difficult process to manage, as he cites that fixed percentages are stipulated concerning the piece of the pie that lawyers would receive if they win, which protects the client from being taken advantage of, or at least feeling that way. He tells us for New York, the figure is 33.3%.
That same 33 1/3 seems to be a reasonable percentage to work with, and it is amazing as to why Trinidad and Tobago has not moved with the times.